Yeah, so welcome, and I want to introduce Max Page in a moment as our presenter, but just a couple of things. First 2 weeks from now, as many of you know, we have this webinar every 2 weeks. We're going to have Laura LaCroix Dalhoun from the Minnesota Coalition on Targeted Home Visiting, and she's going to talk about the connection between targeted home visiting and child maltreatment. They have a very powerful, well-organized coalition that's been promoting targeted home visiting, and it's one of the few programs where there's significant research showing that it actually prevents child maltreatment. I think the ideal thing for all of us is that families don't end up in child protection in the first place because they're not abusing or maltreating their children. And she'll talk about that coalition, how they've managed to pull together a very diverse group of organizations and make some headway on some tough legislative issues. And I also want to mention, we stay away very carefully from any fundraising on this forum, but I do want to mention an event coming up that if you are so inclined, you could maybe promote or share on your social media, and that is that our board chair is doing a 50-mile walk. I mean, yikes, 50-mile walk on Saturday for safe passage, and he's going to stop at all the important sites in the Twin Cities that relate to children on the way, and he's got a group of 10 or so people who are going to share parts of that walk with him. So take a look at our website if you're interested, and we'd love it if you would just share that information around. So Max Page is, as you have seen from the promotional material, an assistant county attorney in the Child Protection Division. Tell me if I've gotten any of these names or titles incorrect, Max. At Hennepin County Attorney's Office, he represents the Hennepin County Human Services Public Health Department in child protection custody proceedings. And also, he's a person he's kind of a double agent. During the legislative session, he represents the county attorney's office of Hennepin County on issues related to child protection and foster care. So really unique role. So he's going to talk about the role of the Juvenile Court, which was a mystery to me for quite a long time in terms of its relationship to the child protection world and what its role is in this. And Max also, we have worked together quite a bit on some of the legislation that is making its way through the session. So I've gotten to know Max a little bit. Been great to work with. So I thought you all would like to meet him as well. So with that, Max, I'm going to turn it over to you and let you run with it.
All right. Well, thanks, Rich and Stephanie and the Safe Passage group here for having me today. The Safe Passage group has always been a really helpful and invaluable partner in the work that I've done, particularly at the legislature on child protection issues, and a really important voice there. So it's an honor to be asked to come speak to this group. I've attended a couple of these presentations that the group has put on, and I can only hope to try to live up to what I have already seen. I am going to try to start first by sharing my screen, and we did this before everyone got on, but I don't know if lightning strikes twice. We'll see.
There you go. Well,
and let's see. All right. Are you seeing my notes or the?
No, you got it now. Yeah.
I got the right way?
Yep.
All right. As Rich mentioned, I am a line attorney with the Hennepin County Attorney's Office. And what that means is I'm essentially a trial attorney. I get cases from the time they come into our office and referred to us all the way until the cases are dismissed or we have, a termination of parental rights. I'll get into what all of that looks like in a minute, but I see these cases from the beginning into the end. I've been doing that work for about 5.5 years. And as Rich mentioned, also for the last 4 years, I have been the legislative liaison for the Hennepin County Attorney's Office as a whole. So anything with regard to child protection or criminal or civil commitments, anything legislative that comes up at the Capitol, I'm the representative for the office, kind of, we are the largest public law office in the state with I believe nearly 200 attorneys, another couple hundred staff. So, our office has a very large interest in, the outcomes at the legislature. And so we have a position dedicated to working on those things. I have been doing that for about 4 years, like I said, and I've gotten to know Rich doing that work. It's nice for me to be able to have a child protection background and be able to work on legislative issues at the Capitol. I went to William Mitchell College of Law back when it was called that, and I have also clerked in Hennepin County District Court and in Crow Wing County District Court in the child protection calendar. I was with a judge up in Brainerd, and so I got to see how some of these things work in a smaller county as well. I also have not completed, but I have begun foster care licensing process. So I have seen the entire system from a few different angles. I am going to try to, it looks like someone's in the waiting room. I'm going to try to open up my chat so that I can see if people have comments throughout the presentation. If there are, feel free to throw them in. I prefer just to, I have a presentation, but I prefer to answer questions as we go along. And if I have an answer coming later, I'll just let you know. So the things we are going to look at today are everything throughout the life of a child protection case, from the time a case comes in, through a child protection report, through investigation and family assessments, through the court portion of what we do, the permanency deadlines and what permanency looks like for children, adoption. I'll touch on briefly the concept of extended foster care, which still does include some court involvement. And then I'll touch lastly on a little special piece called expedited permanency petitions that represent some of the cases we handle in court. All right, so the first thing that happens in any child protection case at the beginning is a child protection report. Now, our social workers and attorneys don't go out into the community looking for cases. We are a reactive organization, and so we don't have a case open unless we receive a child protection report. These are, you can call in, any person can call in to make a child protection report. Just Google the, child protection report in your county, and you'll find the phone number right away, and you can make a child protection report if you have concerns. There's a question, will these slides be available after the webinar? And I'm happy. I think I did email a copy to Rich, and he's more than welcome to share the slides. So just so everyone's aware, child protection reports are anonymous. The reporter, the name of the reporter identity cannot be disclosed. Sometimes it's pretty apparent who makes a report if there's only one individual who could have seen certain allegations of abuse, for example. But technically, all reporters' names are anonymous under Minnesota law. There are mandated reporters, teachers and nurses, for example, and those individuals are required to report. I believe a majority of our child protection reports come from those individuals. And then, of course, there are voluntary people, relatives who call, or, a next door neighbor or something like that. When a child protection report is received, then the individual, kind of like in a 911 call center, except for, child protection only issues, they receive the information, they ask additional questions, and then they use what are called screening guidelines to screen a child protection report in or screen it out. And a child protection report is screened out if there are not allegations sufficient to meet one of the statutory screen in guidelines. And, there can be, anything from a lack of information to a lack of identity over who the individual is, that would mean that something is screened out. When cases are screened in, then there are a couple of next steps that can be taken to get the ball rolling. And the only way we would get to court involvement is through our child protection report that is screened in through those screening guidelines. That screening guidelines document is available online. You can Google it. It's dozens of pages long. It's very specific and provides guidance on whether something should be screened in or screened out. Just so everyone is aware, those decisions are made by the individual screener. In Hennepin County, those individual screeners will, on every case, will consult with their supervisor and with a county attorney in some form will review that decision. Sometimes they're big team decisions, and sometimes it's just a review of what the screener decided to do. Once a report is screened in, then there are two different paths essentially, and I'm oversimplifying a little, but there's two different paths that the case can go down. The first is kind of what I think most people would traditionally think of with an investigation. This is involves a social worker who has that background, who goes out into the community. They are assigned to the case. They attempt to interview the parents, the children. They have authority to go to the school where a child is without the parents knowing, and to try to interview children there and to talk to other professionals. The investigator, they'll also do like a background check. They'll search court records for the parents. And what they're trying to do is determine whether maltreatment has occurred. And there are a bunch of statutory definitions of maltreatment. Again, those are in the screening guidelines. And what they do is they try to make a factual finding. Did this maltreatment occur? And the standard they use in the law is a preponderance of the evidence. And that means slightly more than 50%. So more likely than not, did this maltreatment actually occur? If they did not determine that, then the case kind of goes away, or they can make a referral for services, or the process essentially will stop there for all intents and purposes. If they do find that a maltreatment determination was made, then we'll go to court involvement, and that'll come in the next slide. But that's what happens essentially during an investigation. There's another path that child protection reports can lead to, and these are called family assessments, or FA, they're referred to sometimes. And this involves families where they recognize that they need services. They want to cooperate with a social worker who is trained to work with them to get whatever services they need in place, and work cooperatively to make sure that the children are safe. There's no maltreatment determination made in the family assessment. It's more of a set of individuals, families that are more willing to work with the department. And when I say department, I mean the social workers as a whole. For Hennepin County, it's the Hennepin County Human Services and Public Health Department, but each county has their own social services agency. But I'll use the word department to refer to the individual institution that I represent. You might wonder, if a family starts off being cooperative and wanting to work with the social workers to address those services, but then say they end up having some issues, what we do is we have the ability to move it from a voluntary kind of situation to a court situation. And it says flip from FA to investigations. Really, that means flip from family assessment into a court involvement. So it doesn't exactly go to investigations, but the department does have recourse if a family decides at some point that they're not going to be voluntary, or that court is otherwise needed. So let's say we have a child protection report, it is screened in, and we have an investigation that leads to the social workers wanting to ask my office to file a petition to get them into court. This is usually in order to protect children who have been abused or neglected. There are essentially two kinds of petitions that we file, a CHIPS petition and an order to produce child for interview. I'm going to touch on the second one very quickly because things usually end pretty quickly after we file that petition. But what an order to produce child for interview is, under state law, parents have to make children available for interviews during the investigation stage of a child protection report that is screened in. Sometimes we have parents that refuse to have the child be interviewed, or we just can't find the child. There's any sort of circumstances where an investigator is not able to close out their investigation because they haven't talked to the child. In those circumstances, we go to the court, file our statement of facts, and ask the court to order the parent to produce the child so that the child can be interviewed. Typically, the parent then complies, the child is interviewed, and oftentimes those do not result in court cases where we go back in. Occasionally a child will disclose something, and we will file a petition to adjudicate the child in need of protection or services. So that's kind of the order to produce child. The other petition we file, which is our most common one, is a CHIPS petition. And this is an allegation that a child essentially has been abused or neglected, or meets some other statutory definition in Minnesota State Statute 260C.007, subdivision 6. There are 16 different categories of allegations that most bad conduct against children fall into. And that can be anything from, exposing the children to a dangerous environment, not caring for their needs, physical or sexual abuse, educational neglect, prior child protection history is one of them. So there's a bunch of different definitions, and we have to allege in our CHIPS petition which of those apply to this particular case. And ultimately, what we are seeking is an adjudication of the children, and it's kind of a strange legal concept, but it essentially is a label that these children need the government's intervention to protect them or to provide them services. A lot of times people are more familiar with criminal court, I will say, and people equate, criminal charges to these statutory subdivisions, these reasons that children are in need of protection or services. But really, the question for the court is, does this child need ongoing protection or services? Whereas in criminal court, you're mostly trying to prove some past event that happened or didn't happen. So it's a unique kind of label. Child protection is one of the only areas that has this. At the first hearing, and I have the different stages of the CHIPS proceeding on the screen there, the court has to make a decision about whether the child should be placed out of the home and into foster care, or if the child can remain home with a parent while the court proceeding goes forward. The latter is called protective supervision. And in that case, the parent has to comply with certain orders, typically, engage in therapy or, attend chemical dependency treatment in order to keep the child in their care. During the time that the court is open, the department offers the family a case plan. And that's typically that list of things that you would want to see the parent do while the case is open. And the case plan is supposed to be directed at, whatever issues the parent had coming in, whether it's chemical dependency, domestic violence, physical abuse of children, or, inappropriate discipline of children, neglect, and that kind of thing. And the case plan has to attempt to remedy the parents' attitudes and behaviors. Just really quickly, just so you're aware, the department is required to provide what's called reasonable efforts. It's essentially telling the parents about certain resources where they can, engage in those services. Where can they go get a chemical dependency assessment, or where can they enter treatment, or what are a list of therapists that they could go to start working through some issues. Those are called reasonable efforts the department has to engage in. There are stages of a CHIPS proceeding listed there. The emergency and protective care hearing and admit-deny hearing is often combined into one hearing where the court makes that initial decision. We then have a pretrial conference where we try to settle the case. And this is an opportunity for the parent to say, yes, I admit to some or all of the allegations in the petition. I have the insight to understand that my child needs protection or services, and I'm willing to work on the case plan. If they don't agree, and I would say most parents do ultimately admit that they have things that they need to work on, and that they struggle with and that they want to work on, because most parents really care about their kids and have some significant struggles that they've been able to recognize. If they don't, then, or if they disagree that their child needs protection or services, we have what's called a trial. And, the burden is on the social workers and the department to prove, this is slightly higher than the maltreatment determination. This is called clear and convincing evidence that the child is in need of protection or services. And so we will have a trial, just like you might see on TV, where we offer evidence and call witnesses to provide testimony. One kind of unique thing about trials in child protection court versus criminal court is in the Constitution prevents any individual from self-incrimination. And so they have the right to remain silent in criminal cases. That does only apply to criminal cases, however, and so we have, as the attorneys for the department, have the ability to call parents as witnesses, and the parents don't have a right to remain silent. If they do remain silent, that evidence can be used against them, or that silence can be used against them by the court. The court can make a negative inference on their ability to parent. After a child is adjudicated in need of protection or services, then we have what are called disposition review hearings, and these are every anywhere from 30 to 90 days to see if the parent has made progress on their case plan sufficient to return the children home. And if not, then we hold what's called a permanency progress review hearing. I'm going to talk about permanency deadlines now, since this is a natural transition to that. But essentially, the state of Minnesota has decided, and this is true for every state, has decided that children need to have some sense of permanency when they've been removed from their parents' care. And we just know, based on child development, that children do far better when they have a permanent and regular caregiver than when they're being bounced around, or they're in foster care, but they might go back to mom and dad, or mom and mom, or dad and dad for that matter. We just know that children do better with a regular caregiver. And so at about 6 months of a child being in out-of-home placement, we have a permanency progress review hearing. And at that point, the department has a couple of obligations. One of them is to disclose to the court the department's concurrent plan. That is, if the child cannot be returned home, ultimately, what is the backup plan, for example? And is it termination of parental rights? Is it transfer of custody to a relative? At this point, the 6 month of out-of-home placement mark in court is when that plan has to be disclosed to the court and to the parents. We also have the obligation to provide a kinship study to all the court and parties. And this is a study of the family, essentially a family tree with all their contact information. The department has to consider relative placement for foster care before we move children to non-relative placement. That's in statute and is a requirement because we know children do better when they're with familiar people than when they're with strangers. And so the kinship study is something that's also shared at that 6-month mark. The department then essentially has 5 more months to work with a parent before they have to file what's called a permanency petition. And at the 11th month of out-of-home placement mark, the department has to have a second petition filed if the child remains out of the home. The social workers try to discuss this with the parents at the beginning of the case. It's in the court orders from the first hearing, from the CHIPS adjudication, and it's kind of something that's always present, is the possibility that a permanency petition might have to be filed, and that is to establish a permanent living arrangement for that child. The different types of permanency petitions are on the next slide. And I guess reunification is the goal of every child protection case. And that is the best outcome that we find for children if they can remain with their parents or be returned to their parents as long as the parents are safe. If children cannot be returned, then we file the permanency petitions. And I've listed essentially the 4 different kinds there. The first one, and this one is preferred under state law, is a termination of parental rights and adoption. And this essentially severs any relationship that the child has to the parents and establishes a new parent-child relationship with another individual. This is even when a child is adopted, as some of you may know, the birth certificate is amended to put the new parent's name on there, and the old birth record is no longer considered valid. It's kind of an odd thing, but it just shows you the how serious the termination of parental rights process is. The second option is a transfer of permanent legal and physical custody, and this is an option when a child has a good relationship with their parent, but their parent just can't get sober or just hasn't been able to provide a safe home or a safe environment for the child, but the child would benefit from ongoing contact. In those situations, when an individual is able to take custody of the child, we transfer custody, and that allows the parent to continue to have the ability to visit the child, and that the parent can petition the court after 2 years to get custody back. In termination of parental rights, essentially, with some very few narrow exceptions, those rights to visitation and to try to get custody back are gone. The other kinds of petitions that are much rarer but still available are temporary custody to the agency, where the department has 1 year to essentially come up with another concurrent plan, or permanent custody to the agency, where the child remains in foster care until they turn 18. That's available only for children 16 or older in foster care. So those are essentially our permanency options. The most common one, because it's preferred by law, is termination of parental rights and adoption. And adoption has its own set of specialized statutes and court rules and procedures. And when we're going down that route, after parental rights are terminated, typically at a trial or because the parent voluntarily terminates their own parental rights, the child is then transferred to the guardianship of the commissioner of the Minnesota Department of Human Services. The commissioner then essentially has guardianship of the child until the adoption is finalized. In this process, they do an additional kinship study. There are other relatives that can come forward, or if the child's in non-relative foster care, sometimes relatives will come forward and ask to have the child, for them to be adopting the child. And so sometimes you'll have an additional trial during the adoption stage. So it's possible you could have a CHIPS trial for the CHIPS adjudication, a termination of parental rights trial, and then an adoption trial. And there's a lot of due process and a lot of legal steps to get a child adopted. We in Hennepin County have a few attorneys that do adoption specifically. This is one piece of it that the line attorneys do not regularly do. So I've only done 1 or 2 adoptions in my time. So I'm not an expert on adoptions, but there are those attorneys out there. Last couple of things. Extended foster care is another court process, and this is for children who are in foster care when they turn 18 years old and we don't have, we haven't established permanency through termination of parental rights or a transfer of custody. They just have turned 18. They are no longer a child, but our state has essentially established that children can remain in foster care until they turn 21 if they're in that situation. You have to have children who are willing to work or go to school. There's a requirement that they're engaged in some sort of pro-social or community engagement, and the child has to cooperate. But they have a caseworker, and they get financial assistance, and that goes all the way until they're 21. The final kind of court piece that I want to talk about before we just turn it over to general discussion is a special set of cases called expedited permanency petitions. And these are our most serious cases. These are cases involving egregious harm, sexual abuse against a child or against an adult if a parent engages in sexual abuse against adult. Any conviction that a parent has, if they have to register as a predatory offender, the department is required by law to immediately request my office to file a termination of parental rights petition. We skip the whole CHIPS adjudication stage. We just go straight to a termination of parental rights. Another example of this is when a parent has had their parental rights involuntarily terminated or involuntarily transferred to a relative. In those cases, that happens when there's been a trial and the parent has lost at trial, a termination of parental rights trial, or the parent just didn't show up to a hearing, and we move forward by default on our permanency petition. So if a parent has a subsequent child following one of those, then we're required to file a termination of parental rights petition for all of those future children. Those, again, are the more serious cases. And in those cases, the department is not required to provide reasonable efforts to reunify the child and family, but frequently you will see that is something that those efforts are offered anyways, just because social workers generally have a belief that people can change and that parents can acquire new skills or create a safe environment for children. Those services are often ineffective, but there is that kind of underlying belief. So that is really the child protection statutes are dozens of pages long, really complicated stuff, and really technical stuff with a lot of different requirements. I've tried to boil that down all into less than 30 minutes, which I believe I have done. But if there are any questions, I'm happy to, or just people want to discuss, I'm happy to do that now.
Max, thank you for sharing your knowledge. I do have a question. I'm calling in, I'm a parent who has been reported to child protection with no findings, but my child also is using substances. So we've been trying very hard to get him help. And at the advice of my brother-in-law, who's a public defender, he thought that we should file a CHIPS petition. And I'm wondering, how is it? I don't really understand that process, and why would a parent just kind of, can you explain that?
Yeah, thank you, Ms. Hanson. That's a good question. There is the ability for private individuals to file a CHIPS petition and essentially make the same allegation that this particular child needs protection or services. And when doing that, You have to notify the local social services agency that you are filing the petition. They have the opportunity to, enter the case and provide services if they wish. Sometimes they decide not to. I think oftentimes they decide not to, at least in Hennepin County. Typically, when I've seen that, Ms. Hanson, is when it's like an aunt or uncle believes that, their niece or nephew is in need of protection or services, and that the parent's not willing to get help. So there's it's not. I don't handle those kinds of cases, mostly because our department does not get involved in most of them. But I haven't really ever seen where a parent would file a CHIPS petition as to their own children. I don't think there's anything that would prevent that, but I'm not entirely familiar with the private action CHIPS petitions. There may be individuals at the county. A lot of times parents reach out to the county department and talk about voluntary placement agreements or other kind of services that might be available, without any court involvement. But the social workers often want to help and hopefully can at least point you in the right direction if you make that call.
We have a caseworker through the county, and our big issue is that our son is resistant to, he will not voluntarily do anything. So our hands, we really feel like have been tied, and that as parents, we're trying to get him help. And right now we have sent him to a wilderness therapeutic dual diagnosis program because we have felt like in the state of Minnesota, we are trying to get him help and we can't.
Yeah, no, I mean, that's often what we're just asking our parents to try to do, is to get them help. So I do wish you luck, and I hope for the best for you and your son.
So thank you for answering that. I appreciate it.
Max, I had always thought there was a somewhat different process for CHIPS for kids who are in the juvenile justice system. And I don't know if that applies here. But aren't there CHIPS petitions for kids who are like, chronic runaways or whatever?
Yes, so there's a couple different CHIPS categories that are statutory subdivisions where a child is either has committed a delinquent act when they're under the age of 10, and those are not delinquency cases; those are CHIPS petitions automatically. There are also most of the bigger counties have programs that try to use a team approach to the juvenile delinquency and child protection case if they both come in at the same time, and try to offer the most therapeutic or cooperative services rather than trying to come down with a hammer on them in juvenile delinquency court. And if your county is not doing that, it would be worth suggesting some sort of process to begin that.
One addition to that, I know truancy is another piece of this, but unfortunately with COVID, it wasn't being enforced. So I was like, oh, okay, right.
Yeah, COVID has really kind of upended a lot of our practices, and educational neglect and truancy is one of those areas where there's been a lot of leniency, and the tracking, the data has not always been really useful.
So thanks for that question.
Mr. Gardner, it looks like.
Yeah, go ahead. Whoever else wants to jump in.
I'm gonna jump in, Rich, as you knew I would.
Yes.
I'm a bit of a ringer in a sense, Max. I'll warn you that up front. I'm a retired child protection supervisor from Hennepin County. I worked there for 37 years. So could you just address something that I like to emphasize, and that is the fact that the decision for a child to be placed out of the home is not a unilateral decision by anybody, that the child protection worker and supervisor have to reach that decision. They then have to consult the county attorney's office, and they have to concur, as well as have legal sufficiency to file the petition. And then on the third level, the juvenile court has to agree and ultimately make the decision in order for the child to either remain out of home if it's like on a 72-hour police hold, or to be removed from the home if the child is still currently in the home. So it really is a team effort with like a 3-level check and balance system before a child is placed out of the home.
That's a really good point, Mr. Gardner, and thank you for your work that you did as a in the Child Protection Division in Hennepin County, and I'm following in the footsteps of you and your team working with the county attorney's office. Then that's exactly right. That you know, this is a cooperative decision that's made after consulting with the county attorney's office, starting about 3 years ago. There was an additional step that was added in. You know, we have really bad racial disparities when it comes to out-of-home placement for Native American children and for Black children. And in order to make sure that we were even making more of a team decision, to make sure that implicit bias and race was not informing our decisions, not only did the supervisor and the social worker and their supervisor have to make a decision, they had to get the program manager who supervises above them, who I'm sure you're aware of. So there's essentially 3 levels within the social workers department to agree on out-of-home placement before, you know, consulting with the county attorney's office and getting, you know, that decision made. But yeah, I mean, and not only is the out-of-home placement decision, you know, a cooperative one with the county attorney's office, but so many of the other steps along the way, you know, to dismiss a case ultimately, you know, sometimes the social workers will agree this family is good to go, or, you know, whether the best decision is termination of parental rights or a transfer of custody. Sometimes, you know, that involves a lot of discussion and teamwork. And so I would say that, yeah, social workers, the department, and the county attorney's office really work hand in hand, and it's to everyone's benefit if they work well together.
Max, can I ask on that point? You said the county attorney has to review every screening, but I wasn't clear. You know, and sometimes it's in the process and sometimes it's after the fact. Does that include screen outs or just screen ins?
That's for, in Hennepin County, that is for every decision. And again, sometimes it's a, you know, a big group decision where some of them get referred out to an attorney and a bunch of social workers and service providers, and they make a decision. Other times it's just a decision that's made that's reviewed then by the county attorney's office. But, and this isn't true for Hennepin, I'm sorry, all counties, but it is true for Hennepin County. Sarah asked if screen out reports are sent to DHS licensing for review. So the decision to screen a case out and not involve, you know, get involved any further is documented and recorded in the statewide SSIS. Mr. Gardner can probably tell you what that stands for. I can't recall off the top of my head, but
Social Service Information System.
There it is. Those are documented in the Social Services Information System, SSIS, which is accessible by all social workers statewide, is accessible by individuals making those decisions. So that is available. If a report is screened out a bunch of times and we keep getting the same report of similar allegations, then that can be used to inform future decisions. With regard to DHS licensing, I believe they can get that information. But yes, it's a statewide system for that reason.
Oh, can you guys hear me?
Yeah, go ahead.
Hi. Okay, I just have a quick question. I know you mentioned that reunification, you know, it's the ultimate goal of every child protective case, but you also mentioned that termination of parental rights and adoption is preferred under the law. Could you kind of explain why that would be preferred, or kind of like the reasoning why that would be preferred over a transfer of permanent legal and physical custody?
That's a really good question, and thank you for that. There are people that disagree about which one should be actually the preferred outcome for children. My understanding of why the statutes were initially written the way that they are is that a termination of parental rights creates a more permanent outcome for the child. There is not that possibility of, oh, maybe in 2 years, mom or dad will petition to try to get me back into their custody. It essentially establishes a new caregiver going forward permanently. And so that's the way we want to go forward with children. There are some individuals who I think will be trying to pursue a change in that law in the near future, in the next few years, because they believe that, you know, that severing of parent-child relationship damages the identity to children and has a more negative effect than establishing the permanency. Those are all things that we try to weigh in really heavily, or carefully, I should say, when we're making the decision to terminate parental rights or transfer custody. But that, I think, is the reasoning initially from the legislature.
Okay, thank you.
Max, something I'm a little unclear on is if there is a maltreatment finding, does it always go to court so that there's a court weighs in on the case plan that the family has to follow? Or is there a version of an open child protection case where there's a finding of maltreatment that doesn't actually get into the court process?
Yeah, so there's no requirement that says, all right, maltreatment determination, maltreatment is found, so now we go to court. If they find a maltreatment, make a maltreatment finding, and the family is willing to engage in services, it's possible to not enter court after that initial stage. And sometimes parents, like in those situations, also voluntarily want to work on those issues. Mr. Gardner, did you have additional thoughts on that?
Yeah, I don't know what the numbers are right now, but at least, and I've been retired for like 6 years now. When I left the county and I supervised in the investigations area, of the cases that we opened to ongoing services, I think the percentages were running around 35 to 40% were court involved, and the other 60 to 65% were not court involved. So the majority of the cases that were open for ongoing services were not involved in court. Now, some of those, as the case progressed, might end up being referred for court later, just as some of the cases that are opened with court involvement may be dismissed from court fairly early on in the case, and the case still goes on for ongoing services. So there's kind of an interplay back and forth between what's open in the court, what's not open in court, and what's open for ongoing services. But the numbers back then were running that 60 to 65% non-court involved, 30 to 35% court involved. But that was 6 years ago.
My guess is, and that those numbers all sound like they would probably be similar now. I think we probably have even lower court involvement now because the county has made some significant investments into upstream or pre-court services to try to get families the footing underneath them that they need to prevent court involvement. Because that out-of-home placement, everyone should know, when a child's placed in foster care, that's very expensive, and the costs of paying for foster care are really high. Amy, Ms. Hansen had asked temporary custody to the agency. Temporary custody to the agency is typically based on when a CHIPS adjudication is actually based only on the parent's behavior and, I'm sorry, the child's behavior and not on the parent's behavior, and essentially when services are needed for that reason. And it's essentially additional time to establish a plan to get them back home or to get them in a better placement. Occasionally they'll be in a residential treatment placement. I've put the statute in the chat, Ms. Hanson, so you can look at, I think there's 4 different things that have to be met for that to occur. It's subdivision 6 of 260C 515.
Just another clarification too is that just because a case is involved in the juvenile court doesn't always mean that the child is in out-of-home placement. There are a number of cases where the children or the child remains in the home or is transitioning back into the home under what is called protective supervision. So court supervision of the case is still active, but the children are in the home.
That's a really good distinction. We do have a lot of those cases.
So I don't want to, I have things I can follow up on, but I want to leave room for anybody else to jump in before I do so. So one thing I'd like to ask, I'm interested that now, I don't think it's always been the practice that the county attorney gets engaged in screening decisions, whether screening in or screening out, because as you know, historically, many of you know that one of the things Safe Passage has talked about a lot is the fact that up until there was a governor's task force on child protection in 2015, statewide, only 27% of maltreatment reports were screened in, and that was compared to more than double that number in an average state. I think it was 63% at that point. So so when Max sort of said, well, the official thing is that a case has to meet the statutory standards in order to be screened in, the decision about those statutory standards was being made by county social service departments. And we did some research with the Institute of Child Development that indicated that cases that should have been screened in, many cases that should have been screened in weren't, and we reported many, many times before they finally got over that threshold. So and then after the governor's task force, there was legislation that said all the counties had to follow the same standards, and the Department of Human Services had to promulgate those standards. So we went from 27% up to 43, 44% of cases being screened in. So I guess my question to Max is, do you see a change, in your time, or do you have a feel for whether cases are, being screened in when they do meet the criteria, or is there still work to be done in that?
That's a good question, Rich. And I should explain the reason that that our office is involved in all the screening decisions, at least at some level, is because Hennepin County was subject to a lawsuit that it was not being protective enough of its children, essentially. And well, we were facing another lawsuit at the time that we were being overprotective of the children. But ultimately, as part of the settlement of one of those cases was the requirement of a multidisciplinary team reviewing all of the screening decisions. And I have been one of those attorneys that reviews some of those decisions. And I can tell you, I think they make the right decision 99.99% of the time, at least aligned with what the screening guidelines say. And the screening guidelines may not perfectly cover, the spectrum of human behavior is so wide and broad, and it's really hard to predict every possible bad thing that could happen, or, risk factor that can happen. And so what those screening guidelines do is try to establish a set of standards that in Minnesota we believe that children should have this basic minimum level of care. And I think the decision that the department makes is legally justifiable pretty much every time, even if some of the situations you say, well, you know, that seems like a risk factor. You know, maybe we just don't have enough information. You need to get more information before making a screening decision. And sometimes that does occur. But I think, I don't know what the long-term numbers would say with Hennepin County right now. But I think the approach that we are taking is helpful.
Well, that's reassuring to hear. I think it's almost impossible to get those screening numbers. You know, they come out from the state between a year and two after the fact. So you can't really get a window into what the percentage is. And also whether there's reasons why Minnesota might be different from other states. So there's just a lack of basic data to say, hey, things are going in the right direction or they're not. So it's good to hear you say you feel that they're doing it well.
This might be a question more for Stephanie as a technical issue. There's a chat message that was sent directly to me, but I don't know how to respond to it.
Yeah, if you look at the chat, are you looking at the chat window right now?
Yeah.
Okay, so
Sorry to.
all right, I'll message you.
Or basically, I can just mention to Sarah, yes and yes, and we can go from there. And Stephanie, if you could send me a link somehow that I can communicate with Sarah directly, I'd appreciate it. Thank you.
Well, I think if it was directly to you, you could just go to where it says type message here and type a response, and it says direct message right above that. So you should be able to type your response and just hit enter and it'll go. It'll go just to her. Stephanie, tell me if I if I gave you bad advice there.
Yeah, no, Rich, I'm messaging Greg about that privately, so you can keep going with the webinar.
Okay. So Max, the situation where a parent can come back in 2 years and say, hey, you know, I've gotten my life straightened out, et cetera. That must be tough on the kid, right? I mean, maybe if they're with an aunt or something, it's not so difficult and they've had ongoing contact with the parent. But if they're in foster care and they don't hear from the parent and the parent shows up like 2 years later and they're in high school or they've got their life somewhat normalized and predictable, and then, wow, do I have to go through this again as a kid, you know, or maybe they want to go through that again, but it seems like it would be kind of living in limbo.
Yeah, so that's a good question. You know, we try not to, you know, when we transfer custody to a relative, it's with the understanding that the child is going to have ongoing contact with the parent. And so the possibility that they might go back to the parent, if the child doesn't want to go back to the parent, you know, is going to be minimized because they're going to have ongoing contact. And that's going to be, you know, something that is okay with the kid and family typically. You know, oftentimes the children do want to be back with their parents. You know, they would even testify at trial that they, you know, despite abuse or despite neglect or whatever, that they would rather be in their parents' care. And so, you know, it's really hard to say with any, you know, sort of broad stroke, whether a transfer of custody is damaging in and of itself. If we are running into those situations where the thought of a child being returned to their parent is damaging, then that's a case that's more likely going to be a termination of parental rights would be more appropriate.
Right. Well, I mean, and I know that that's the ideal and that's the goal, but we've run into so many situations where children are returned time and time again to homes where they continue to be abused, and then they're removed back to the foster placement or the relative, and then they're put back in again. And by the time they're, 10 or 12, they're cooked. They run out to the street or whatever. So I just, and maybe things have changed, but the decisions that have been made to keep returning children to their bio parents over and over and over again, despite ongoing harm, are, it's certainly, I don't know if it's still the pattern, but it certainly has been a very prominent pattern in situations we looked at over the last 10 years or so. So, you can, I'm sure you can recognize that we're a little skeptical about the official version of that, because we've seen so many kids, including kids who say, I do not want to go home. I absolutely do not want to go home. And they're sent home again and again anyway.
Well, it's an interesting point and a good one, Rich. I would say there's a difference between, children being sent home after court involvement, they're reunified, and a transfer of custody. For all the transfers of custody that I do, I get notice of when a parent, petitions in the future for custody or visits. And I can tell you, it so rarely happens where a parent petitions for custody after those 2 years. I occasionally receive a motion where a parent who's had custody transferred away from them, they're asking for additional parenting time or a change in parenting time. But very rarely are parents then asking for full custody back. We have one supervisor that handles all of those cases when those requests are made. The social services department has the opportunity to become involved and work with the family again if they wish. But I would say, at least from the transfer of custody perspective, those are very rare occurrences.
But isn't there, I thought there was a version of permanent adoption where you still had an open relationship with the bio parent. And it sounded like you were saying no.
Well, so there, in a termination of parental rights, another slightly different version is a consent to adopt, where the parent says, I'm okay terminating my parental rights as long as this person is the only person that's considered for adoption. Usually it's a relative. And in termination of parental rights or consent to adopt, there may still be contact, and quite honestly, there oftentimes is contact between parents and children. It's just that the parents don't have a enforceable right in court to go, say, I'm not getting visits with my kid. I want them, you have to give them to me. It's completely up to the individual who adopts them.
Rich,
so
are you referring to an open adoption?
I might, based on what you said, Greg, I might be thinking of situations before there's a final determination in court, because what I've run into, I have a whole caseload of grandparents who say, hey, I had temporary custody, and they keep sending the child, this 5-year-old child back to their bio parents for trial home visits, or sending them home, and then they bounce back to me, and they come back from these trial home visits, with injuries, or evidence of being sexually assaulted, and they talk to the social worker, and the social worker says, no, we're on this plan to reunify. So maybe that's before there's any permanent decision. But as I say, I have a caseload of grandparents with, who have those complaints. There's several lawsuits that are, in process right now along those lines, saying that children were forced to go back into situations where there was evidence that they were harmed. I think Hennepin may be a little different, Max, from the rest of the state, because you've done so much work there, even before the class action lawsuit required you to do stuff. The county just stepped up and kind of almost became the leader in the state in terms of good practice. But I think around the state generally, kids are still being sent back to situations where there's evidence that the abuse is continuing. So I'm wondering if that's like pre-court decision. Maybe that's where I'm a little mixed up on the process.
That can happen really at any stage of the process. And sometimes the court will send children home over, the social worker's objection, the parents' attorney will argue that, you know, they've done everything on their case plan, they've changed their attitudes, child should go home, when really the parent hasn't changed their attitude. And ultimately, that's a decision that a neutral arbiter, the court, makes. There are cases where sometimes you just don't get it right. It's a constant risk assessment, and you try to do the best you can. You try to act in the children's best interest, but you know, I acknowledge that that's not 100% of the time, and nor is it anywhere. But yeah, that, you know, children can be sent home any point from that first hearing to 3 months through a case to, you know, on the day of trial, the termination of parental rights trial, the court could say, you know what, kids are going home. I don't think that we should even have a trial.
Yeah, and I'm not trying to put you on the spot. And I think, as I say, Hennepin has really worked on some of these issues in a way many counties haven't. But those are the things we're seeing statewide, which are kind of different from kind of the process you described.
Yeah.
And it could be that a lot of that has changed statewide too, and we just haven't caught up with it because of the lack of data. There's just such a poor way to look. You know, you can't really get a view into individual counties until years after the fact. So let me just go back and see if others, you know, do have questions, because and also we're kind of a little bit over time too. So I didn't realize it's been going so quickly. So let me just.
I have a quick question if I'm able to ask.
Yep, go ahead.
So I'm wondering, when it comes to the child's been out of home for 11+ months. There is a TPR that has been filed for trial for like this fall. And the birth father is now out of prison. And so now is he going to get, like, he's getting the opportunity to run a case plan, but I'm wondering how that affects the length of time the child is out of care. If it's already been 11 months and then he got out at month 11, TPR is for mom, he's not on it. How much longer is the child going to be, you know, kind of just sitting in this limbo spot when they've been out of placement for already 11 months?
Thank you for the question, Ms. Rivers, and it's a really good one. You know, we have these statutes that say 11 months, we should have a permanency petition to give that child its, you know, final home throughout childhood. And the rules say a trial should be starting within 60 days of that petition. Now, I can tell you in Hennepin County that rarely, if ever anymore, happens. You know, that the court is allowed to go beyond those 11 months if it has to make certain findings to extend that timeline and essentially find that it's in that particular child's best interests. Now, courts sometimes do that, sometimes don't, but that's what should be happening. You know, in certain circumstances, you know, where a child maybe is on the cusp of going home at 11 months, but the parent needs, you know, a couple more months just to like get an apartment or something. You know, the court, there's a statute that allows the court to extend those timelines up to 6 months. Now, you know, again, I don't know if they always make the findings to meet the standard of that statute. That's what they should be doing. But it does allow them to do that. There are other reasons that things get extended, you know, beyond those timelines. You know, you try to keep it at about a year, but court schedules is another reason that, you know, we just have such a jam in court where we can't get in. You know, if we don't have a settlement agreement at month 12, well, the next trial date is not available for 2 or 3 months. So, you know, there's a lot of things that can extend that time period for better or oftentimes for worse. But it's, you know, these cases, particularly, you know, people getting out of prison, the judges often want to give those individuals opportunities. So, you know, any number of circumstances could lead to an extension.
Thank you.
But it doesn't go on and on the way it used to years ago. There's just some pressure to get it resolved. Am I right?
There should, it should not go on and on forever. I have some cases where it feels like that is the case. We work really diligently, and our county has specific reviews for children who have been in out-of-home placement longer than they should be, and start to apply a little more pressure in meetings with the bench or the court, that is, and in those hearings to really try to force the issue to find that child a permanent placement. Sometimes another example is, we have a child who we finally, say at month 10 of out-of-home placement, we finally found a relative for them to go to. It's a really good relative, but they are just starting the licensing process, and it might take them 3 or 4 months to get licensed. And we want to have the child in that home, but we also want to make sure that that home can be licensed before we, do a transfer of custody or something like that.
Well, I think maybe I should call it at this point, just because, you can email us at contact us at what is it, Stephanie, safepassageforchildren.org. We just
Yes, that's it.
That's it. We just recently changed. With follow-up messages, we'll put the PowerPoint on the website. And I just want to say once again, 2 weeks, we have a presentation on the Targeted Home Visiting Coalition and what they do with LaCroix Dalhoun, and she's going to tell you about all that and how it relates to child protection. So we hope to see you then. So thanks all for coming, and we'll see you in a couple of weeks, we hope.
Thanks, Rich.